Also here with us is Miss Christina Cabrera, who is the aunt of the children and lives with them.
And Your Honor, it's Robert Greening. I'm here as guardian ad litem for the minors in this matter A, B, and C, D. And you have appointed me guardian ad litem for the sole purpose of this claim against Miss Eagle. And that's what we're going to prove up here today.
Okay.
And Chad Archibald here on behalf of defendant Eagle.
And everyone else, have they made their announcements? Okay.
Mr. Duran is here, I believe. I can see who's here. I just can't see your faces.
Yes, Your Honor, I'm here, but I believe I'm here more as a party and not as counsel, along with Ms. Cabrera, who's the guardian of the person.
And then what about Mr. Willett?
Mr. Willett is my co-counsel, Your Honor.
Okay. All right, let's go ahead and proceed.
Your Honor, on behalf of the plaintiffs, we would make the following presentation. With the court's permission, I'm going to ask Mr. Duran questions, but I'm not going to, unless the court wants him under oath, I don't think that's necessary for my purposes.
Okay. That's unusual, but
Okay, then let's, as he's an attorney, let's go ahead and swear him in.
I mean, if he's providing sworn testimony, he needs to be sworn in. So please raise your right hand. Do you swear or affirm the testimony you're about to give show the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Let's proceed.
State your name, please, sir.
My name is Michael Duran.
Mr. Duran, do you understand that you have been appointed the guardian of the estate of Jazeera Cabrera? I'm sorry, Jazeera Leon and also Mariah Leon,
Yes, sir.
and that they are known also as A, B, and C, D in the pleadings in this case.
Yes, sir.
You understand, Mr. Duran, that with your permission and with a court which appointed you's permission, our firm, along with Jason Willett, was hired on behalf of the children to pursue claims arising from the death of their parents, Roberto Leon and Teresa Leon.
Yes.
And have you had an opportunity to review and approve our contract, as well as present it and obtain the approval from the probate court?
Yes.
And you understand that, subject to his honor's approval, we have entered into a settlement with Ms. Caitlin Eagle, who was the driver who caused the crash leading to the death of Roberto and Teresa Leon.
Yes.
And you understand that there were multiple claims against Ms. Eagle as a result of this incident, and that as a result of that, some of this $60,000 policy eroded or was used to pay other claims.
Yes.
Okay. Do you understand? I'm not going to say the amounts now. I think that might be confidential, but do you understand that 100% of the remaining funds are being tendered on behalf of the minors in this action?
You mean on behalf of Miss Eagle to the minors?
Yes. Yeah. Exactly.
Yes.
And do you understand that our firm is not taking any fees or expenses out of the portion, out of the funds that are being tendered on behalf of Ms. Eagle to resolve this matter?
Yes. Thank you.
And do you believe that it is or is not in the best interest of these children for his honor to approve this settlement?
Yes.
You have to say which.
That
it is in their best interest or not in their best interest?
Is in their best interest.
Thank you very much. Your Honor, that's all the questions that I have.
Any other questions for this witness?
Mr. Duran, I have a couple, Your Honor. Mr. Duran, you and I have spoken on the phone a couple of times about this settlement. Is that true?
Yes.
And you and I discussed together what the best course of action would be to invest this money that's going to be going to A, B, and C, D, correct?
Correct.
We talked about the fact that there may be a trust that's going to be set up in the probate court for some of the other settlement monies. I also had some annuities run, and ultimately we looked at everything in conjunction with talking with Christina And we decided the best course of action would be to put this money in the registry of the court for Judge Hoffman to put this money in the registry of the court, correct?
That is correct.
All right. And we did that because we felt like that was going to be the best way to handle investing this money, because the trust would be too onerous, possibly too many fees, et cetera. And the structures just were too costly with this amount of money. It wasn't gonna provide any positive investment. It was just not the right way to go with it. Correct?
That is correct.
Okay, and that's all I have. I'll pass the witness.
No further questions, Your Honor.
Any additional questions of this witness? Okay, call your next witness.
Your Honor, that's all we have with regard to the presentation of the settlement agreement from Ms. Eagle. If you'd like, I'll go on to proving up the claims now against Psycho Cinnamon LLC.
Thank you very much.
I'm really confused. What's
Your
going
Honor.
on? Why isn't Ms. Cabrera being called?
Yeah, I was going to ask,
I'll be glad to call her. Ms. Cabrera, would you please raise your right hand so that the judge can swear you in?
Ma'am, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right.
Tell us your name, please.
Christina Cabrera.
Ms. Cabrera, what is your relationship to Jazeera and to Mariah Leon?
I am their aunt.
And is Ada Cabrera their grandmother?
Yes, she's my mom.
Do you live with Mariah and Jazeera?
Yes, I do.
And have you lived there since the time of their parents' death?
Yes.
Would you please tell me who is the mother? Who was the mother, please, of Jazeera and Mariah?
That was Teresa Leon. That was my sister.
And the father, please?
Roberto Leon.
Would you please tell the judge just a little bit about the relationship between Roberto and Teresa and their two children?
They were very, very close. My sister had tried years to have kids, and it took her a while. So she loved her girls very much. When this happened, they were on their way to the drive-in, which is one of their favorite things to do. So they were very close.
They were going to the drive-in movies over in Ennis,
Yes.
and were both, from your knowledge, were both Roberto and Teresa killed in this crash?
Yes.
Were both of their children in the vehicle when this crash occurred?
Yes.
And from what you've seen, did both Jazeera and Mariah have some?
Wait. I'm sorry, Mr. Casada. I apologize. I think my court reporter got knocked off. I didn't notice that.
Can you hear me, Judge?
Yeah.
Okay,
I'm
I'm sorry, Mr. Greening, you were asking the question and you were talking about the investing the money in the registry of the court, and then I just froze up. I'm sorry. That's the last thing I got.
So did you get any of Ms. Cabrera's testimony?
I did not. It froze up on Mr. Greening's questioning. I'm so sorry.
Y'all, so it's up to y'all. We can start over again or kind of go back to that point, or this is all on YouTube, so she could get this off of YouTube if anyone, unless anyone objects.
That's fine with me, Your Honor.
I have no objection.
Mr. Casada?
No objection, Your Honor.
All right, so just if you could just Miss Christina Cabrera has been testifying, so let's go ahead and go forward.
From what you have seen, Ms. Cabrera, did the deaths of their parents affect both Jazeera and Mariah?
Yes, it affected our whole family, basically.
And would you tell the judge just a few examples of how you've seen the death of Roberto and Teresa affect these children?
They've been sadder, obviously. They're less outgoing. They're starting to get back to themselves because it's been 4 years, but I mean, it was a rough couple years, and I mean, we're pushing through it. So, but they're different people than they were before all this. I think the whole family is different.
And can you tell me whether the death of Roberto and Teresa appears to have affected every single aspect of these children's lives.
I would say so, yes.
Would you tell the judge just a little bit about the sort of parents now that you believe Roberto and Teresa were? Were they loving and nurturing and guiding parents for their two children?
Yes, they were. They were all of that and more.
And in addition to providing love, support, guidance, comfort for their children, did they also demonstrate that? That
Yes,
is not,
they-
yeah. Not only did they love their children, but they showed their children how much they love them.
They did, yes.
Do you have any reason to think that Teresa and Roberto would, if it had not been for their deaths, would they have continued on in loving, nurturing, caring, providing for, and being with their daughters?
Yes, they would have.
Okay. Your Honor, do you understand, Ms. Cabrera, that subject to the court's approval, that the case against Caitlin Eagle will be settled today if His Honor approves that?
Yes,
And do you understand that if His Honor approves the settlement in this case, that the claims against Ms. Eagle will be over with forever, and that no matter how bad the situation gets in the future, we could never again come back and sue Ms. Eagle for anything related to the deaths of Roberto or Teresa Leon?
yes,
Do you understand that by entering into this settlement, you've given up the right to have a jury determine some of these issues?
yes,
And do you understand that if His Honor approves the settlement, the plan is to put the money for Jazeera and Mariah, to put it aside so that they can access it when they get older?
yes,
And do you understand that this is not my money or your money or Mr. Willett's money or Mr. Duran's money or even the guardian ad litem, Mr. Greening's money, that this is instead money that is set aside only and exclusively for the children?
yes, I do.
And the proposal is to divide the amount available in half. Let me ask this. Did both Mariah and Jazeera suffer equally as a result of what happened to their parents?
Yes, I think
And
so.
did Roberto and Teresa love Jazeera and Mariah equally?
Yes, I think so.
Do you understand that Mr. Willett and I are not going to be taking any attorney's fees or expenses out of the settlement with Ms. Eagle?
Yes,
Now, have you had a chance over the years, have you had a chance to visit with Mr. Duran and have him answer any questions that you might have had about how he is serving as the guardian of these girls?
yes,
And have you had a chance to visit with Mr. Willett and ask any and all questions, and my office, and ask any and all questions you've ever had about how, about this lawsuit and the claims against, in this case, Ms. Eagle?
Yeah.
Do you have any complaints, any criticisms of Mr. Willett's efforts or my efforts or anyone with our office?
no, I don't.
Your Honor, that's all the questions I have. Thank you.
Greening?
Ms. Cabrera, it's Robert Greening. You and I spoke on the telephone a week or so ago about this matter. Is that true?
Yes,
And at that time, you and I believe that Mr. Willett was on the phone as well. And we discussed at first placing this money into this trust that Mr. Duran is in the process of getting approved. And that's kind of what we thought about that we would do. But then later, that I spoke again with Mr. Duran about the trust and Mr. Willett. And then we decided against that after looking at the annuities as well. I spoke to you about the annuities, true? Is that true? We
Yes.
spoke about the annuities, and then we also spoke about the trust. We made the determination we'd put it in the trust, but then later I spoke with Mr. Duran and Mr. Willett more about the trust. And we decided probably the better course of action, the most cost-effective economical thing to do with this money would be to place it in the registry of the court. And so we changed our minds, and you and Mr. Willett have discussed that since we changed our mind about that, correct?
yes,
And you're of the mind that you would say you would agree that the money, after considering all the options for investment, should be placed in the registry of the court. You agree with that? True?
yes.
and that you believe that this settlement is in the best interest of your nieces A, B, and C, D, correct?
Yes.
And we spoke about how they're doing, and obviously this has been a devastating loss to them. But I believe you told me when we spoke that they're doing about as well as they could possibly be doing under the circumstances, correct?
Yes, I think so.
And they're not currently in any sort of therapy or treatment, psychological or mental health treatment, correct?
No, not right now. They did it right after the accident, but not right now.
And you don't see that they're going to need that as far as you can tell right now.
I don't think so. Not right now. Maybe once they're a little older, but not right now. No.
Okay. And you understand that if this money goes into the registry of the court, then it would be available to A, B, and C, D upon their reaching the age of 18, correct?
Yes.
All right. Are you asking Judge Hoffman to approve this settlement as we've been discussing it here today?
Yes.
All right. I'll pass the witness. Thank you.
Any more questions of this witness?
None, Your Honor.
Your Honor.
Your Honor.
All right. You ready for your report, Mr. Greening?
Yes, Your Honor. I e-filed my report yesterday along with an order. We e-filed it late yesterday afternoon. However, I will just say that, thank you to Tex Quesada's firm and Mr. Willett's firm for not taking a fee or expenses out of this matter. The fund, it was a 30/60 policy. There was 36,374 left on the policy. I have verified that I've seen an affidavit from Miss Eagle stating that's all the insurance that she had. I've reviewed the other two payouts on the 30/60 policy, and they were less money. Both claims were less money than these girls are getting. And so I'm comfortable with that. Obviously, it's the insurance company's call who they settle with and when, but I agree that Texas firm and Mr. Willett have done a great job getting as much as they can of the 30/60, especially considering they're not taking any fees or expenses. So with everything being said, I would ask the court to approve this settlement. And I believe it's in the best interest of both of these girls to put this behind them and get this done and place the money in the registry of the court. My fee is $3,160. And as far as I understand, I had to spend a little more time on this case than I would have otherwise because of all these different moving parts. So it's a little bit higher than it probably would be otherwise. But the defense, the Bassett firm has agreed that my fee is reasonable. So I just wanted to throw that in. And that's all I have, Your Honor. Thank you.
Is that agreed to, Mr. Archibald?
Yes, Your Honor, that is true.
So let me ask you this. Are there settlements with other defendants as well? Are we proving those up, or kind of what's the deal with that?
Your Honor, there have been settlements with other defendants, but as they were approved by the probate court, which appointed Mr. Duran, since he is dependent. That is to say, he cannot approve anything unless and until the probate court approves it. We've already had a hearing proving up the settlement of the other defendants other than Psycho Cinnamon, and those defendants did not want a guardian ad litem. They felt protected because the probate court had already approved it, and there was no conflict of interest between Mr. Duran and the children. That is because he has no personal claims. There's absolutely no conflict. And so that's the reason that they did not ask for an ad litem to be appointed in this case. And they were comfortable with the hearing that was had in front of the probate court and the ruling from the probate court approving Mr. Duran's authority to settle that case.
And then Judge Hoffman, if you'll recall, when I first got appointed in this, you guys were having a hearing and you called me from the hearing and you said, we're thinking we need a guardian ad litem on this. And everybody sort of had this discussion. Do we need one? Do we not need one? And I don't know whatever happened, but all of a sudden I got the order. So it was a little confusing, but I think we worked it out.
And you're comfortable with all this, Mr. Greening?
I am. It took me a while to understand it all, but I've spoken with Mr. Duran at length, and I think that the fact that this defendant wanted a guardian ad litem, Ms. Eagles wanted a guardian ad litem in this particular thing is, as they say, what, belt and suspenders, so to speak.
Okay. Mr. Willett, Mr. Archibald, do you have any objection to anything that's happened so far? You cut out there. Could you say that again?
No, no objection, Your Honor.
Okay. So you said something about Cinnamon, but not the other defendant.
Yes, Your Honor. What we'd like to do now is, with regard to the claims against Psycho Cinnamon LLC, that's a company. It has no attorney. It has not appeared for trial. The court called this case to trial. On behalf of the plaintiffs, we waive a jury. We're going to present to the court. We've presented a judgment. We filed a proposed judgment and emailed a judgment to you, Your Honor, asking that you award damages to the A, B, and C, D based upon past and future mental anguish, past and future lost consortium in society with each of their parents. So each girl then would have 8 blanks. We've submitted that to you. You've already heard the evidence about the close family relationship and the children's contemporaneous perception of the events here. In order to conclude the proof against Psycho Cinnamon LLC, I'd like the court to take judicial notice of the fact that Caitlin Eagle was found guilty, pleaded to, and was found guilty of intoxication manslaughter in the death of Mr. and Mrs. Leon in cause numbers 43347 CR and 43348 CR out of Ellis County, Texas. And so we know that her intoxication was the cause of the death of these. The issue then becomes whether or not there was evidence at the time that the provider, in this case, Psycho Cinnamon LLC, provided alcoholic beverages to Ms. Eagle. There, for proof that she would have been obviously intoxicated at the time, unless anyone has objections, I'm going to offer the resume and report of Dr. Harold Miller, who points out that Ms. Eagle's blood alcohol content approximately 1 3/4 hours, which was the blood was drawn 1 3/4 hours after the car crash, that at that time the blood concentration of alcohol was calculated to have been 0.249, and I'm sorry, would have been 0.249 at the time of the collision. Let me say that again. They drew blood almost 2 hours after the collision. Working backwards, her blood alcohol content would have been 0.249 at the time of the collision. And Dr. Miller points out that at the time she was provided alcoholic drinks earlier that afternoon, she would have presented a danger to herself and others because she had obvious signs of intoxication. With the court's permission, I'll submit that report and resume separately to the court reporter so that'll be online. And with that, Your Honor, unless there's any questions, that concludes our presentation against Psycho Cinnamon LLC, and we'll submit it to Your Honor's discretion as to the amount, if any, to be awarded to the children in damages for the deaths of both of their parents. And you are on mute, Your Honor.
Any objection?
No objection, Your Honor.
So, Mr. Casada, let me ask you to do this. Go ahead and submit a final judgment. I guess you submit it with blanks. Is that the idea?
Yes, Your Honor. Would you like for me to put in some suggested figures?
Yeah, why don't you put in suggested figures? Also, at the beginning of the proposed judgment, put that we heard this on March 31st, 2022, and I haven't seen this. Make sure it says that this is a final judgment and this will dispose of all claims.
I will do that, Your Honor.
If you haven't already done, you may have already done that.
I'll make sure that it does.
Okay. All right. Mr. Archibald, do you want him to share that with you or?
I believe they've got Aaron tagged on the email chain, but if they wanted to send it over to me just to make sure that we get it in the right spot, that'd be perfectly all right.
It'd be great if you could get this to me by tomorrow. Mr.
Well,
Casado.
And to be clear, there's a separate judgment already submitted, approved, and uploaded, waiting for your honor's signature to take care of Caitlin Eagle. That one's
It's
already
not it's not a final judgment.
That's right. And then when you get, your honor, you'll get this afternoon the proposed final judgment against Psycho Cinnamon LLC, and you will also recite that it disposes of all claims and all parties.
And it includes the amount of damages you're requesting.
Yes, your honor.
And
All
your
right,
honor,
guys, thank you so much. And you guys, thank you, Mr. Greening. Your fees are approved. Make sure that that's also in the judgment at the agreed amount of the fees. If it's
or
not
Judge
already in there.
Judge Hoffman, I don't think it's in the judgment they submitted, but I submitted a separate order with my fees. Is that okay?
I mean, it's best if it's, Mr. Casada, can you include that in the order too? I like it to have it all.
Not a
in one
problem.
document if
Not a
possible.
problem, your honor. We'll get right to it.
Okay.
All right, thank you, guys. You
Thank
guys
you.
are excused. Have a great day.
Thank
Thank
you.
you, Your Honor.
Okay, we now have the pre-trial conference. Let me go ahead and go on the record on that. Let's go on the record on DC 209-893 Moss v. Princip. Council, make your appearances.
Morning, Your Honor. Craig Capua and Royce West on behalf of plaintiffs/judgment creditors.
Gene
Okay.
DeBose, representing defendant Holly Bone.
Morning, Your Honor. This is Brian Martin Pro Se for defendant. And thank you very much for allowing me to speak in your court, Your Honor.
Okay. All right, let's go ahead and get started. I instructed the parties to confer on motions and limines, proposed exhibits, as well as any other pretrial matters that needed to occur. And I also understand that there's been a very extensive jury charge that has been submitted. This case has been specially set for quite some time. I told everyone last week that this case was going to have a pretrial this week. I didn't know for sure when, and we set it after I've figured out how long my jury trial this week was going to last. I understand the parties, at least one of the parties, has not complied with my instructions, and so I've never had that happen in 16 years on the bench, and so I'm in kind of uncharted territory here. Let's deal first with plaintiff's motion in limine. Have you submitted a motion in limine, Mr. Capua?
Yes, Your Honor, I did.
Mr. DeBose, do you have any objection to plaintiff's motion in limine?
Many, I only got it an hour ago. I also just got a 195-page charge, again, minutes ago. We've had no opportunity to confer on it.
Is that correct?
There
Mr.
are-
Capua?
And there are a number of things that I'm clearly going to be able to agree to, but others we will not.
Your Honor, may I respond?
Did you send the court the motion in limine?
I believe we did. If it didn't make it, I can send it again.
I don't have it. Let me see.
Okay. I'll get the paralegal.
Send this to the court. Send that to the court.
It's being resent again, Your Honor. My apologies for the court not receiving it. I had emailed Mr. DeBose yesterday about exchanging all of our pretrial materials at 5 o'clock, so we would have an opportunity to review and confer. But he stated that he would not be ready, and so then we agreed to exchange our pretrial materials today at 8:30 a.m. and both sides did comply there. I mean, I reviewed his exhibits, and
I'm
Your Honor,
looking. I don't see the motion in limine.
it's being sent again as we speak, Your Honor.
Rhonda, can you go ahead and forward me the motion in limine if it's come in? I see the charge.
Waiting on it to come in now, Judge.
And Your Honor, as it relates to the charge, that's a draft of the charge. There'll be other iterations, but that is kind of the direction we're going in terms of the case.
It's 192 pages long.
195, I believe. I have only 3 items that I want included in the charge.
Your Honor, if you look at the amended petition, you'll see the various causes of action. And the court will know we've got to make certain that we capture all of those causes against all of the parties in the charge. However, there's an issue, Judge, in pretrial we need to discuss is how to handle Brian Martin, since he has a default judgment. And depending upon how that is handled as relates to the court, that will impact the number of pages in the charge. So, you know, we're seeking direction, guidance on how we do that in terms of him already being found guilty of most of, if not all of the causes of action that are in this particular lawsuit.
Okay. I mean, it's just 195 pages is, I've never had a charge over 50. And so I don't quite understand why this would be so complicated, but I haven't read the charge. I've glanced through it briefly, but I have not read it. So I don't know the issues.
And you may not have to read the whole thing. I think how we handle Brian Martin's failure to comply with court orders and the default judgment will affect the length of the charge. And we just need to get direction from the court on how that should be handled.
I mean, I don't want to retry the issue that's already been decided in the default judgment. And so
I'm sorry,
and so but again, I noticed there was like a civil conspiracy. There was all sorts of other claims. But let's deal first with the motion in limine. Did you forward that, Mr. Capua, and Rhonda, you sent that to me?
Ms. Benson, did you receive it?
Not yet.
Judge, and e-filed and sent to you also.
I don't have it. Rhonda, have you gotten it?
Not yet, Judge. Would you like me to call the office, their office?
But they're on the line right now. They're on the Zoom call. They said they just sent it.
It's been e-filed, Rhonda, and sent to the court.
You sent it through e-file?
7 a.m. to directly to Rhonda.
It went to you, Rhonda, at 10:37.
10:37. Okay, I see it now. Okay, here we go. Just one moment.
Go ahead and forward it to me.
Here it goes.
And Mr. DeBose, have you sent your motion in limine yet?
I don't have any.
You don't have a motion in limine?
No.
Okay. All righty. Well, how long is this? It's only 8 pages. Okay. Let's go ahead and deal with the motion in limine, plaintiff's motion in limine. Which motions in limine do you have an issue with, Mr. DeBose?
With 2, with 3.
All right, so 1 is granted, 2. 2 is granted, 3.
Your Honor, there's
3 is
one.
granted. Okay, so go ahead and just tell me what you have a problem with.
Well, I do have a problem with 2 and 3.
Okay, those are both granted. Those motions in limine are both granted. What's your next one?
Okay. No problem with 4. No problem with 5 or 6 or 7 or 8 or 9. Both parties have, I'm not quite sure what number 10 means as to pretrial orders, because both parties are submitting into evidence the injunctions of the court, and I don't know that that falls.
What does that mean, Mr. Capua?
As it relates to number 10, Your Honor.
And yeah. Because I've seen that before as any reference to the court motion in limine, but any pretrial orders, you mean at any point in the trial? I mean, any point prior to the day of trial?
Yeah, I can withdraw it. I mean, that's fine. I think there'll be a lot of orders marked as exhibits, so we're okay with that.
All right, 10 is withdrawn. Any other issues?
11, because there are damages which were not involved in any discussion. There was no request for those, for the damages.
I mean, is there a request for disclosure in this case?
Yes, Your Honor.
Yes. Yes,
11 is granted.
12, I'm okay. 13, okay. 14, okay. 15, okay. 16, I'm not sure what all that means.
I'm sorry, I couldn't hear you, Mr. DeBose. What did you say?
I'm trying to read 16.
All right, 11 through 15 are granted.
I'm just not. I'm not quite sure.
16 is denied.
17.
Seventeen is granted.
18. No problem with 18.
18 is granted.
19, no problem.
19 is granted.
We both have videos
Yeah,
that
20 is denied.
And again, I guess no problem with 21
It was granted.
or 22, no problem.
Granted.
But I don't know about, that's to Martin.
So 23 is kind of an interesting issue. So there's a default judgment as to Mr. Martin. I agree with you that he can't testify. This is kind of interesting. He can't testify about anything that would be contrary to the default judgment, but he could testify about issues that are not covered by the default judgment.
Yeah. For example, damages.
Damages, yeah, or yeah.
And he will be given a lot of background information. So I'm not.
Therein lies the
sure.
problem. He'll be given a lot of quote unquote background information.
Yeah.
And so, if Judge, and I know judicial efficiency, and so we may very well, excuse me for the noise, there's construction going on in the building.
That's okay.
We may very well need to take him outside the presence of the jury to see exactly what he's going to testify to see whether or not it's inconsistent with the default judgment. So we won't have to be jumping up and down the entire time. That's just a thought.
I don't think I'm going to be using him for things that are.
I can barely understand you, Mr. DeBose. Could you speak up?
Oh, I'm sorry. I'm sorry. Can you hear me now?
I can.
Yeah.
Okay. He will be doing a lot of background testimony about what he was doing with and for Ms. Bone, their relationship, things like that. I don't think any of that bears on his liability. It may bear on hers. So I'm just not.
He's never been deposed, right?
He has not ever been deposed. I'm just not sure I see the necessity of that. But again, if it's limited to liability, I guess, limit and
you keep on going down low, sir, and I'll do respect. I can't understand.
Yeah, Mr.
I'm
DeBose,
sorry.
Yeah, I do agree. That's
Your Honor, can I give you an example?
sure.
As it relates to the issue of fraudulent transfer, he's already been found guilty of that.
Right.
Conversion, conspiracy.
I think the main thing I could see him testifying about is the only issue in my mind that really hasn't been resolved in this case, which is why it's so confusing that there's a 195-page charge, is the ownership of the disputed assets. And does Mr. Martin own them or Ms. Bone? I think he could testify about that. Other than that, it's going to be very limited what he could testify about. I don't know background what that means exactly, but background as to that issue, I think is okay. Just general background, that strays too far from that, I would think probably not.
And Judge, while you're thinking about that, there's also the default judgment against Carolyn also. And so depending upon how the judge views how those default judgments should be presented to the jury, it will, in terms of evidence and in terms of instructions in the charge, it will greatly reduce the charge.
Okay. All right. Well, 23 is going to be granted in part, but modified. He cannot testify about anything related to or in contrary to the interlocutory default judgment. He can provide testimony about ownership of the disputed assets.
Your Honor, if I may.
Sure.
Thank you, Your Honor. The main issue I have with this entire case is that these YouTube channels
Mr. Martin, that's not what we're covering today. So,
well, they're celebrity
apologize.
assets.
You could talk about number 23,
Okay.
but that's it. So, if you want to address 23, but we're not going through and re-arguing your whole case.
No, I wasn't arguing it, Your Honor. I was just saying that these channels are celebrity channels. Everybody knows them. They've been viewed over 1 billion times. I provide a lot of information because I've been a part of these channels for such a long time. That's all I was pointing out.
I don't necessarily disagree with them on that. I do think that he can provide some history about these channels.
Thank you, Your Honor.
But, you know, if he starts straying into issues related to the default judgment, Mr. Martin, if you start straying into issues with the default judgment, trying to re-argue those, then I'm going to have to shut your testimony down, which obviously is not what you want. So I'd encourage you to strongly be very, very careful about your testimony. Let's go to 24.
Yeah, before you go to 24, in terms of ownership, that's already been determined by the default judgment. I mean, follow me just one, I'm not trying to argue with the court on it, but if the court granted a default judgment for fraudulent transfer, the fraudulent transfer initiated with Brian Martin. And for him to say anything otherwise as it relates to the transfer would be inconsistent with finding in the default judgment.
I agree. Related to the transfer, I agree with you there. The issue is who owns the disputed asset? Who owned the disputed assets? Was it Miss Bone? Because there was not a default judgment as to Miss Bone or Mr. Martin. I can't grant it, and if I did, I'd have to vacate it. I can't grant a default judgment saying that Mr. Martin owned this when Miss Bone is claiming that she owned it. And so the issue here is going to be discussion of who owned these assets. That's what happened after that point. I agree. If Miss Bone owned it, then I can't see there being a, trying to think this through. Yeah, I don't know how Miss Bone, if she had owned these assets, if she could fraudulently transfer them. It's because she owned them. So it was only to the extent that Mr. Martin owned these assets that we would, that there would be a fraudulent transfer claim. So I just think this comes down to the issue of ownership. Let's go to number 24. That is,
I have strongly opposed that because Ms. Bone's autism affects her entire personality. Not to be able to bring that up, and a lot of the way she thinks, the way she acts is unusual. To not allow her to testify about that or about how it affects her would be like in a lawsuit where somebody was, the question would be whether they heard a comment or not, and bringing up the fact that they're deaf would bar that because she is
24 and 25 are denied, but we're going to keep it limited. All right, that's the motion. Plaintiff's motion in limine. I've ruled on all of those now. Defendant's motion in limine. There is not one. Do we have an exhibit list for the plaintiffs?
Yes, Your Honor.
Okay. Did you provide that to the court?
Yes, Your Honor, when we did with that previous email.
Oh, it's in the email. I didn't see that. Let me go check it.
Sure. Let us make certain, Your Honor.
I don't see it with that email.
Okay. Mr. Cappi is checking on it right now.
Your Honor, with respect to their exhibit list, there's some things on it I know, I've seen. There are a number of things that are just named there. I just sent them an email asking them to provide me with about 20 of those exhibits, because I don't know what they are. I don't know whether they've been previously produced or not. So.
Mr. Cappi, you're going to say something?
Yes, Your Honor, I apologize. I thought Mr. DuBose was finished. I can tell the court that any exhibit on our exhibit list has been submitted to Mr. DuBose through discovery. We're not asking for any exhibits to be.
But I still don't know what they are. They may have been. I have received massive numbers of documents. A lot of those may be objectionable because they're hearsay or unauthenticated. And those are objections that I think cannot be ruled on at this point. When I hadn't seen
how many exhibits are we talking about?
The ones that I haven't seen.
No, I'm just, how many total exhibits are we talking
54 exhibits. Some of them are very large.
What I would suggest we do at this point, two things, and I'm maybe a little bit optimistic about this. The first one is for the exhibits. Let's reconvene at 2:00 so Mr. DuBose has an opportunity to confer with Mr. Capua about the exhibits. And then for the charge, 195 pages, Senator, Mr. West, if you guys could provide me maybe just an edited charge that says, this is what we need no matter what you do, assuming that you do what we think you're going to do with the default judgment, these are the things that we would need if say, for example, I vacated the default judgment or the default judgment didn't exist. These are the additional questions we would need. So I have some idea of what you're talking about, but I don't have any intention to vacate the default judgment. I don't have any intention, any of the default judgments. I don't have any intent. I have intention that those are in full force and effect as to Mr. Martin. The question is just as to Ms. Bone. I don't believe it should harm her defense on issues that are solely related to her. And so, does that make sense?
It makes sense. There's also a default judgment as it relates to Brian Martin's mother also. So,
okay. All the default judgments, whatever there are.
Best case scenario.
And I would ask if you can, I have only 3 issues that I want to be in the charge. One is you've accused her of a fraud, so it's a fraud issue. The second is it's actually a copyright issue. That is the ownership issue. I don't know if you have that in your thing. And the third one is the provision of the family law, which is that the earnings she gets are what called personal earnings, and that's defined it's been defined by the Supreme Court. Those 3 issues I need to have in the charge. And I think the first thing that happens has to be, I've phrased it as a copyright issue because that's the only way that this can be owned. That's what you're owning, is the copyright. And that should be absolutely the first issue, because if that's decided in favor of Ms. Bone, the whole rest of the case against her goes away. So I think and Judge, you're absolutely correct. That's the central issue. The rest of this stuff may follow, maybe not. I have massive numbers of issues. But if the jury decides that she owns these videos, she created these videos, then the whole case is over.
Well,
So that needs to be there. It needs to be absolutely right at the front, after all the usual.
I agree in part with you, Mr. DeBose. I do think the ownership of the channels is not a copyright issue. The ownership of the videos is a copyright issue.
Yeah, and the thing about the channels is that
the last part of it.
I'm sorry, Mr. West.
Judge, you were saying something. I didn't hear the last part, what the court was saying.
I said that there's the ownership of the channels is not a copyright issue, I don't believe.
no, but the thing is that according to Google's own terms and conditions, nobody owns the channels. It's a license. They allow people to do these things, and they can take it away whimsically. They have done that in this particular case. They've just taken it away and closed it down. And their terms and conditions say that there are no contractual relationships. It's just a convenience that they allow to people. So the real issue here, because the channels are unownable, is the videos themselves. And there's a kind of a presumption that if you are filing a video on your channel, that you created it, because their terms and conditions and again are very specific. You should only post on your channel that to which you have copyrights. Or
so Mr. DeBose, I get that. So, and remind me again, for each particular video, when someone gets paid or an entity gets paid from Google for advertising revenue or whatever, is it paid by video or by channel?
By video. As a matter of fact, they have a very careful auditing on this stuff. And if you are the person who has the access to the channel, you want to call them owner, whatever, then every time money is paid, you can go to each video and see how much of the income comes from that particular video. It's very, very specific stuff. So all the channels are is the avenue through which the income that's due to the videos comes to the person, and then it goes into whatever account. And in this case, all the money that we've seen went into Ms. Bones' account.
Your Honor, may I respond briefly?
Sure.
This case is not complicated. Here's the issue, Your Honor. If you and I are married and I upload these videos, I say that Judge Hoffman is the owner of these videos because there's a judgment against me. So I don't want to say I'm the owner. No one's going to check unless someone files a complaint. Well, since you and I are married, well, of course, you're not going to file the complaint. I'm not going to file the complaint. It's only going to be a third party who's going to file the complaint. That's the whole basis of this lawsuit in a nutshell. So just because you upload a video doesn't automatically mean you're the owner of the video. Google and YouTube presume it is because that's their terms of service. But what does that mean? It doesn't mean anything. It's not like you're signing under oath, you're the owner of the video. And that's what the evidence is going to show.
Sounds good. Let's shorten up this charge. You guys confer on the exhibits. We're going to reconvene at 2 o'clock. And Mr. DeBose, have you provided an exhibit list to Mr. Capua?
I have, and I've provided all the exhibits as well.
Okay, so you guys need to confer on this. We'd try to pre-admit as many exhibits as possible. And we'll discuss that at 2 o'clock. Also, if you guys could discuss the charge between now and 2 o'clock, that would be great as well. And hopefully we can get this shortened up. We'll see you guys back at 2 o'clock.